One of the most common terms in the legal negotiation of your settlement will be relationship property. This is defined as the property that must be divided between the parties when their relationship ends. Relationship property will usually include your family home, chattels, the family car, household furniture, and anything else owned by the family or used for family purposes. Now, some of this seems obvious, and we have talked about it in section 1 about shared marital assets. Where it gets tricky are the things that your spouse might consider relationship property and you might consider your own, as in separate property. We've all heard the tales of people squabbling over the record collection or a favourite pet. These might seem trivial and funny now, but believe me, these things do happen. Anticipating what might be important to your partner to keep post-separation and deciding early on what items matter to you is really critical. There will always be some give and take, as inevitably you will both love the same things, so someone has to lose out. But being clear up front on what you want and what you are not prepared to compromise on is important information for your lawyer or mediator to know as you enter into the settlement negotiation. Let's talk now with Kalev Crossland, a partner at Shieff Angland, who is an expert in relationship property settlement negotiations. Thank you, Kalev, for joining me today.
Thank you. It's been a pleasure to be here.
So, Kalev, what are the common problems that you see in relationship property disputes?
Okay, to answer that question, the first key thing I'd observe is the setting that people are in. You've got to understand that some people have been in a relationship for 5, 10, maybe 20 years. So you can imagine two trees that were apart that have now got their roots, have grown together and weave together. So there's emotion there, there's finance, there's family relationship, there's the same friend network. And so you're starting off with that environment. You're trying to unravel these two root systems. So that's the setting. First key problem is going into something like this ruled by your emotion. Okay, it's really important to go and get somebody objective to assist you with the process. If you don't do that and you cut a deal early, there's real problems and you will regret it probably 6 or 12 months later. So there is a second problem would be information disparity. Okay, so you may have a situation where there's been a person in business and the other party has been the homemaker. The person who's been in the business, who may have created family trusts or investments, they'll have all the information at the fingertips, but the other party, the homemaker, typically won't. Related to that problem, Bridgette, is there is a power disparity in terms of finance. Regrettably, what I see in some of the higher end divorce fights is that it's a battle of attrition, and the party that has got control over the purse strings can use the legal system and the attendant delays to wear down the other party. And it's really sad because sometimes I see people having to take unfair deals because their war chest is smaller and they can't handle the attritional warfare that still goes on in relationship property disputes.
So what do people need to be really clear on before they come and see you to act on their behalf?
Okay, the first and really obvious point is that is the relationship really over? My experience is that after Christmas time in the new year, we'll get quite a flurry of calls with people wanting to find out about their rights and entitlements. So you'll have a meeting with them, lay all of that out, and then you won't hear from them maybe for 3 or 4 months, and actually things have sorted themselves out. So don't plunge in. You know, marriage can be a bit of a marathon. I know I'm on the second one, and fingers crossed I'll go well on that. But in all seriousness, lawyers who are following the ethical obligations will insist on the client being very sure on that. Often parties will be sent off, or the court will send them off to go and get counselling to ensure that they are sure that they want to take that step. Okay, so let's assume that we've got to that point, absolutely sure about it, and as I said in my earlier example, we'll have people coming in, you know, just with some initial inquiries, but probably 6, maybe 8 months down the track, yes, they are serious to move. So at that point, what is really useful and to have available, firstly, is information, and there's a sort of a Machiavellian aspect to this. If you are planning on leaving, it is useful to gather up all information. So that might be in the case of where there are trusts, having a copy of the trust deed. If there are companies, having copies of maybe the last 5 years of financial accounts, shareholders agreements, trust resolutions. Often couples will work together quite intimately in a business, so you will have a good understanding, we've got a big deal coming up in 6 months, but it may be that that deal was the result of 2 years' work during the relationship. So all of that type of information is really, really helpful for a lawyer to have. Now, allied with documents, it's very helpful, and you will save money with your lawyer if you've done what I would call a chronology of the relationship. So that's when you first started dating, when you moved in, if you had a civil union or a marriage, and what were the major purchases during the relationship. How were those purchases funded or secured? Because we'll find out later when we perhaps talk about what is and what isn't relationship property. Separate property, if it's been used to secure the acquisition or involved in other relationship property, may itself become relationship property. So having a chronology of the relationship along with the business history or the acquisition of the house or other investments is very, very helpful. Thirdly, what is helpful for a lawyer to understand is, if you can, to be very clear on what your outcome is. You may, strictly by law, have an entitlement to $15 million. That's 50%. But if you're like me, hey, if I can get 10 mil quick and be rid of this person, I'll be happy with that. So if you're up front and tell your lawyer, look, I don't want the full shebang, there is real value to me in making a clean break, I'm prepared to compromise, that's of great assistance to your lawyer.
Is there any legal protection over certain items or rules on how things should be split?
Yes, there are, Bridgette. Now, for those people that had good presence of mind before entering into their relationships, they may have got a prenup. So when you've got a prenup, obviously there are some rules, because the two parties, before they've gone into the relationship, have pre-planned and said, look, if things don't work out, this is what's going to happen. Now, of course, lawyers wouldn't be in business if there weren't ways to sort of wiggle around a prenup, but wriggling out of prenups now has been made more difficult in recent years, because there was a law change that said that to set aside a prenup, not only did you need to show injustice, but it needed to be serious injustice. But let us put that to one side, because the majority of people don't have those. So the main battleground, in my view, or one of the major battlegrounds in relationship property disputes, is the demarcation between what is relationship property and what is separate property. Now, there are some obvious examples that fall into the category of the latter, namely separate property, and those would include examples such as jewellery that one party has gifted to the other. That is separate property. Although, interestingly, the quality of that gift, once people start fighting, is sometimes regarded as, oh no, well that's joint, a conditional gift. But clearly jewellery is separate property. In a similar category would be inheritances, although that comes with a condition. If the inheritance has then been introduced into the relationship property pool, for example, it may have gone into a batch along with some borrowed finance, and that borrowed finance is paid by joint resources. You can see stuff getting mixed, and as a general rule of thumb, once it's sort of become mixed like that, then it's going to become relationship property. So a lot of the debate amongst lawyers is whether some asset has lost its quality of being separate property. Now, Bridgette, New Zealanders love trusts, but most New Zealanders don't understand trusts. They'll talk about my trust or his trust or her trust. When you set up a trust, what you're actually doing is you're divorcing yourself from ownership of that property, and you will have a mum and dad who will have a trust, but what they don't understand is whilst during the marriage or the relationship everything's hunky-dory and no one really pays any attention to assets that are owned in trust. Once they come to separation and divorce, assets that have been placed in a trust aren't owned by either of them. Now, there are legal means or way around which the courts will perhaps divvy up that trust, but that is an added complication. It's not something that we can sort of explain in the context of this interview, but sort of red lights around trusts, and consider those carefully when going into a marriage.
Thanks for your fantastic information.
You're welcome, Bridgette.
As part of your documentation of your assets, also consider more personal items that might have significant emotional meaning to you and how you would feel if you had to give them up. Prepare now so that when and if the worst happens, you are prepared to fight for what you want or make compromises on things that matter less.